Welcome to IOL PowerPoint 2022 presentation for Law of Evidence and Criminal Procedure, polled IT22. Tutor's information is hereby sent to you, dear student, for your information. Introduction. Law of Evidence and Criminal Procedure covers Unit 1 to 9, preparation for examination. Students are encouraged to read this presentation with the study guide for better understanding. Consists of 1 times assignment, 120 marks with a pass of 50% and above to qualify for exam, and 12 credits. 3 times examination papers, 120 marks each with 50% pass mark and above. 3 times questions, 1 equals to 70% basic level thinking, 2 equals to 20% requires thinking, and 3 equals to 10% high level of thinking is required. This will equip students with detailed knowledge of the principles of law of evidence and criminal procedures, provides skills and competences necessary or relevant in investigation of crime and court procedures, analyze and evaluate procedural principles applicable during arrest, search, entering premises, and seizure of property connected with criminal acts. To understand authorities and powers of the prosecutor, to understand the requirements for lawful arrest, search, and seizure of property, burden of proof, specific kinds of evidence, nature of evidence, oral, real, documentary, indirect, and circumstantial. Admission and confession, relevancy, admissibility, and the way of evidence. Opinion, similar facts, character and hearsay evidence, preservation and preparation of evidence, principles of cross-examination. Unit 1, authority and powers of prosecutor. Authority of the prosecutor, eminent, remains with the state. The Republic of Namibia, the office of the Prosecutor General in Namibia is a constitutional establishment. In terms of Article 88 of the Namibian Constitution, Prosecutor General is appointed by the President on recommendation of the Judicial Service Commission. Powers of the PG: to prosecute in criminal proceedings in the name of the Republic of Namibia, to defend appeals in the higher court and the Supreme Court, to perform all functions relating to the exercise of such powers, to delegate the other officials subject to his or her control, direction and authority to conduct criminal proceedings in any court, to perform all other functions as may be assigned to him or her in terms of the law, any law. Constitutional right, not a political appointment. Secondly, exercise quasi-helical functions. Unit 2, requirements for lawful arrest, searching and seizure. Lawful arrest. The arrested person should be informed of the reason during or after the arrest in the language he or she understands and judge's rules. Taking physical control over the arrested person should be brought to the prescribed authority as soon as possible, e.g., police official, or to the place of custody mentioned in the warrant, section 50, subsection 1. To be mindful that the custody of an arrested person for longer than necessary is unlawful if may result in claims for damages. Says section 20 CBA, if reasonable grounds without doubt exist, the state may seize anything either within or elsewhere, consent, afford evidence, and intended to be used in crime. Seizure of property. Seizure under search warrant, seizure without a search warrant, police officer, search of arrested person, and the seizure of articles and search of premises. State security, Section 25. Information under oath, where internal security of the Republic is likely to be endangered. Police officer in the investigation of an offense. Requirement of search warrant shall be conducted in a decent and orderly manner. A woman to be searched by a woman only. Section 30. Authorities. Police officials to dispose articles after seizure, such as perishable articles, stolen or suspected to be stolen, other types of articles. No criminal proceedings are instituted, or if no, required for criminal proceedings in case of admission of guilty and fine is paid. The types of articles, no criminal proceedings are instituted, or if no, required for criminal proceeding in case of admission of guilty and the fine is paid. Article to the transferred to court for preparation of trial after commencement of criminal proceedings, Section 34. Forfeiture of article to the state. Disposal of articles concerned in an offense committed outside the Republic. Unit 3. Burden of proof. Each criminal case must be proven beyond reasonable doubt against the accused by the state. Criminal liability. Prima facie proof and conclusive proof at first sight or first impression. Prima facie case. A case based on prima facie evidence. In criminal law, the prosecutor on behalf of the state brings an action against the accused to which the state shall prove beyond reasonable doubt that indeed the accused is criminal liable for committing the offense before the court. If the case creates doubt regarding the criminal liability of the accused, the court must acquit the accused. In common law, the state has the burden of proof beyond reasonable doubt. Section 217, subsection 1, clause B of the CPA made 2 changes. Confession to magistrate. Any of such confession does not need any other proof. Secondly, it is deemed to be freely and voluntary made in sound and sober sense. Evidence. Ascertain the truth as facts. Prove what the law says. Probability. Apply what the law finds to be the truth in any real sense. Unit 4. Specific kinds of evidence. Evidence provides proof and are presented in court by different means. Major types of evidence: oral, real, and documentary evidence. Oral evidence: words spoken by witness in court, viva voce. The witness appears before court to give testimony. Written affidavit or under oath. Subpoena: witness solemnly swears before court to tell the truth in public. Provides the accused the opportunity to confront the witness and challenge this evidence through questioning. Real evidence: material objects for inspection by the court, such as weapon used in crime, appearance of a person, tape recording, fingerprints, and photographs. Unit specific kinds of evidence: handwriting, printed document, and blood test. Documentary evidence: any evidence by means of which information is recorded or stored, such as book, map, plan drawing, or photograph. Pamphlet, letter, circular letter, list record, placard, or poster. However, documentary must meet or obey 3 basic rules before admitting document as evidence. First, the content of the document must be relevant to the facts in issue. Secondly, the original document must be produced. Lastly, the document must be authenticated. There are 3 types of document, being public document, private document, and official documents. Unit 5. Taking of admission and confession. Confession, unequivocal acknowledgement of guilty. The equivalent plea of guilty before a court of laws. All the elements of the offense must be admitted or satisfied without any possible defenses should be excluded. Admission out of court to all elements of the crime charged. Requirements of confession made by accused himself or herself to peace officer freely and voluntarily. Sound and sober sense without having been unduly influenced. And 217 of Criminal Procedure Act, peace officer, magistrate, justice of peace, and police officer. Constitutional right of confession or admission. Right to remain silent, not to be compelled. Legal representation or minimum of self-incrimination evidence. Admission. A statement or conduct adverse to the person from it emanates. Taking admission, type of admission, formal and informal admission, requirement voluntary and sound and sober sense. Why exclude voluntary obtained admission? Possibly unreliable forced admission to uphold the privilege of self-incrimination and to protect citizens from abuses. Unit 6, Relevance, Admissibility, and Weight of Evidence. Police officer investigating a case who testifies as a witness in court should produce reliable and relevant evidence to the court. For the court to reach the correct decision based on the available facts before it. Failing to adhere to the rules of the law of evidence, which is inadmissible. Admissibility and exclusionary rule. In criminal cases, the prosecutor and the defendant may present evidence to support their case. State bears the burden of proof and proving guilty beyond reasonable doubt. Therefore, the accused or defendant presents evidence to challenge the state's case. Given the opportunity to review evidence before court and object to the inclusion of certain evidence before or during trial, the evidence must be obtained in a constitutional manner. Otherwise, the defendant may move the court to exclude evidence that the state obtained in a violation of their constitutional rights. Relevant evidence may also be excluded if it was obtained in an improper or unconstitutional manner. Evidence comprises of materials, information relating to the subject matter of the legal proceedings submitted to the court by the parties to enable the presiding officer to judge and to settle a dispute. This includes witness testimony. The relevance, admissibility, and the weight of evidence. This includes witness testimony, written statement, audios and video recording, photographs, physical objects such as weapons, digital evidence such as both data and media stories. Scientific findings such as blood test results, demonstrative evidence such as displays, charts, models used to educate the judge or jury about complicated issues. Guidelines that assist the presiding officer. Section 15, subsection 3 assesses the evidential way of data and the reliability of the way the data message was generated, stored, or communicated. The reliability of the way the integrity of the data message was maintained, the way its originator was identified, and any other relevant factors. 3 exceptions identified by Van der Merwe. If its probative value is outweighed by its prejudicial effects, if it relates to admission and confession, if obtained from the accused after the commission of the offense. Unit 7. Opinion, similar facts, character, and hearsay evidence. The police mandated to collect relevant evidence that will provide as a tool of proof. Such evidence are used in court to evaluate cases and help in reaching a conclusion. Hearsay evidence in common law refers to oral or written statements made by a person who are not parties and are not called as witnesses and are inadmissible to prove the truth of matters stated. Section 244 of CPA, evidence, whether oral or writing, probate, value of which depends on the credibility of any person other than the person giving such evidence. Exception to the rule, Section 216A, common law exceptions, categories, statement by a deceased person, and spontaneous exclamations. Opinion evidence. The witness describes and expresses opinion on the facts she or he observed. Section 210 CPA. Circumstances of admissibility include the relevance of the evidence, the issue on hand, nature of the opinion, such as expert or lay person. Exceptional rule, factum, probans, effect relevant to the effect in issue, which could not be proven without allowing or permitting the witness to state his or her own personal conclusion of what happened, or the ability to speak and understand the language. Similar facts evidence. Facts that are like the disputed facts. The accused has acted in a similar way before, and therefore he or she tends to behave in a certain manner and is more likely to have done what he alleged against him or her. General Rule Section 210 and 211A2 states that evidence of previous similar offenses by an accused shall not be admissible solely to prove the character of the accused, but the court's reasons for its decision to admit or refuse to admit evidence of previous similar offenses shall be recorded and shall form part of the records of the proceeding. However, the exception to the rule is under Section 211A(1) in case of rape and other offenses of an indecent nature. Evidence of the commission of other similar offenses by the accused shall, on application made to it, be admitted by the court at such proceeding, and may be considered on any matter to which it is relevant, provided that such evidence shall only be so admitted if it has significant probative value that is not substantially outweighed by its potential for unfair prejudices to the accused. Unit 7, opinion and continue. Character evidence refers to reputation, disposition of a person to behave in a certain way, specific incident in the personal history of the subject, general reputation in common law, context. Admissibility is covered by CPA subsection 227, not about good or bad reputation, but rather the accused person acted in a particular manner on the alleged specific occasion. Unit 8, preservation and the preparation of evidence. Evidence forms part of an testimony. Writings, material objects, or other things presented to prove the existence of non-existence of a fact. It is used at trial to prove the elements of a case or a defense. Pre-securing of evidence. Crime scene, area where crime was committed, Physical evidence will indicate the presence of the parties involved, securing a crime scene. First responding officer at the scene of crime secure the area as soon as possible to prevent losses of evidence. Recording of information, documentation, location objects need to be moved. Photographs should be taken. Pre-crime scene attendance. Crime scene vehicle must be fully stocked with the equipment and the supplies that are likely needed. No matter the type, compile a checklist of all the activities on a given crime scene, such as the full name, time of notification, and particulars. Preserving evidence, safety of the firearm and collection of the firearms. Physical evidence, marked with an incredible pen, collector's initials, and the date and temporary proof. Blood and body fluids, safety when collecting and handling blood or any other body fluids, protective gloves, face mask, and eyewear. Other ways of collection: paper containers, packets, envelopes, and bags. Liquid stains, non-breakable leak. Proof containers, arson evidence, airtight and clean metal containers, moist or wet evidence, blood, plants, etc. Plastic containers. Preparing evidence. Relevance to prove arson and evidence airtight and clean metal contains most of wet evidence, blood, plant, etc. Plastic container. Preparing evidence. Relevance to prove any of the fact or event. Authenticate the evidence. Original unless law allows a copy. Lastly, lay a foundation. Must certify certain preliminary requirements or lay foundation for admissibility. Types of collection: dry blood or fabric, blood stain on the wall and floors, scrapes several flakes into plastic vial. Containers must be marked, sealed, and tagged. Collect the stain on 2 to 4 cotton tip swabs. Moisten the swabs with sterile distilled water. Then swab the blood. Then blood stain. Body issues must be collected and placed in a sterile vial in sterile distilled water. Types of evidence you need to prepare. Determine every element necessary to prove your case or claim, or to prove the defense to the case or claim brought against you. Determine facts necessary to establish each element of your claim or defense. Determine the evidence needed to prove each fact of your claim, defense. The fourth category of evidence from which to choose: demonstrative, experimental, and scientific evidence. Physical objects, e.g. clothing, weapons, tools, machines, photographs, maps, model, computer, animation, motion pictures, diagram, x-rays, and physical examination. Experimental evidence is a result of experiment conducted outside or inside the court under circumstances similar to those of giving rise to the issue in the case. Scientific evidence is produced by expert scientific techniques such as experiments, chemical and other tests. Documentary evidence, the common type of trial, all kind of writings. Determine handwritten, type-printed, photocopied, photographed, and every other method of recording on any tangible thing and any other form of communication or representation. Written instruments and documents such as checks, receipts, invoices, contracts, leases, wills, and official documents. Witnesses. The best witness for each piece of evidence through testimony and testify as the fact about which they have personal knowledge or expert knowledge. Types of witness. Lay witness includes all types of evidence, events, and facts about which they have personal knowledge. Expert witness matters outside their experience or knowledge of the average person. Discovery evidence obtained in the discovery phase of case through the following methods: dispositions, written interrogations, inspection of document, tangible things and places, physical or mental examination, request for admission, and exchange of expert witness information. Unit 9, Principles of Cross-Examination. An absolute right. Principles of cross-examination is an absolute right and essential to a fair trial as it guaranteed in the Namibian Constitution. Article 12(1)(d), right to adduce and challenge evidence. Right to cross-examination. Sub-article 1(e), right to have adequate time and facility for the preparation and presentation of defense before commencement of and during trial. Denying an accused the opportunity to cross-examination of witness should amount to a gross irregularity in the trial and could impair the validity of the trial. Section 167, Examination in Chief. Court may examine witness or person in attendance with the aim to, firstly, elicit favorable facts from the witness, secondly, to impeach the credibility of the testifying witness, thirdly, to lessen the weight of unfavorable testimony, and lastly, to make the witness give clear evidence. Dear student, of law of evidence and criminal procedure, we have come to the end of our slide. So it's for you to put more effort. As you can see, dear student, this is a shortened summary. You can still read the Criminal Procedure Act on your own as it attached to your study guide for you to understand what procedures to follow, what process to follow in the law of evidence and criminal procedure. I thank you.